Hello. In today's video, I want to do something a little different than I've done in the past. Often in the past, I've had a topic that we've discussed, and what I want to do here is actually just go through a particular document. So there's something that a lot of us have missed over the past couple of weeks. Fair enough, there's been a lot of distraction, a lot of it probably intentional, but there's also a lot of information going around right now that I think really plays more into the conspiracy realm, which, I can't discredit people for that. A lot of those conspiracies end up coming true. But I will say there's a lot right now that's distracting for people, and they're not paying attention to some of the stuff that is actually going on that is potentially significant or potentially dangerous. And so one of the things I want to talk about, which will sound like a conspiracy right from the beginning, is the potential for legalized COVID concentration camps. That is a big statement in itself, and this is not something that I have drummed up from message boards. This is not something that I've seen a few pictures on social media and tried to deduce that that's what it is. This is actual legislation that has been written into a bill and will be entered into assembly in the state of New York. So the bill's name is A416, and what we're going to do today is go through that, and I'm going to read the whole thing and give you a little bit of interpretation of it and sort of explain or dive a little bit deeper further than just what's in the words. The actual text itself is pretty incredible, but we'll discuss it even a little bit further and try to put some of that in context. So we'll get right to it. So this is A416. And as you can see, none of this is straight off of their website, nysenate.gov, I believe it is. If you want to go check it out, you can find it, or you can just search Bill A416, and you can find the text for it. So this is not like I had to go through some clandestine WikiLeaks or something. This is right out there in the open. Interestingly enough, it is pre-filed as of January 6th. 2021. Today it is January 13th. Take a second and think what was going on January 6th. So we had certification of the electoral votes. We had protests in DC, and we also had this entered when no one was paying attention. So this bill, to give you a little background, was first written by Nick Perry in 2015 when we had the Ebola scare, which I think resulted in something like 2 cases in the States. But this legislation was written up then and has now been brought back. And so, like I said, I want to try to put some of this stuff in context. So let's start with where this was created. So Ebola is also a viral disease. The prognosis, the CDC says on average, your prognosis, if you do get Ebola, you got about a 50-50 shot of survival. So 50% fatality rate, 1 in 2 will die. That ranges up to 90% fatality rate and down to 25% fatality rate, but 25% fatality being the lowest, 1 in 4. So we can contrast that with what we have going on right now, COVID. COVID, if you look at the average or the median age in the United States, that's somewhere around 38. So you could say like the average person, the way of thinking of it, somewhere around 38 years old. The survivability rate they break it out, I think, into 35 to 40. But the survivability rate for someone 35 to 40 years old, if they do contract COVID, is 99.96 or 956, something like that. Well below 1% chance of dying of this. But we went ahead and re-entered legislation for a disease that is 50% fatality rate for one that's less than 1. And another little interesting fact about COVID, the average age of death from COVID is somewhere around 77, ranges, kind of depends on where you are, 77 to 79 years old, the average age of death. The average life expectancy in the United States is 78. So just something to kind of put in perspective what it is we're talking about here, and the kind of the rationale behind this bill. So we're predicating on something that's very survivable and typically does not take people before the average person would go anyway. So like I said, we're going to read this line by line, and we'll stop at times and I'll dig in a little bit deeper about what actually this all is. So 416 in Assembly, introduced by Member of Assembly Perry, read once and referred to Committee of Health. This is an act to amend the public health law in relation to the removal of cases, contacts, carriers, and communicable diseases who are potentially dangerous to the public health. So right off the bat, where we say removal of cases, contacts, and carriers of communicable diseases, that all right there means people. Those are individuals. A person is not a case. A person is not a carrier. Unfortunately, that's how we refer to them now. But cases, contacts, and carriers. Anywhere we see that, that means an individual. The people of the state of New York, represented in the Senate and Assembly, do enact as follows. Section 1. The public health law is amended by adding a new section, 2120A, to read as follows. Removal and detention of cases, contacts, and carriers who are or may be of danger to public health. May be a public danger to public health. The provisions of this section shall be utilized in the event that the governor declares a state of health emergency due to an epidemic of any communicable disease. That governor would be Andrew Cuomo. He declared multiple states of emergency in the state of New York in the year 2020. So it's not that crazy. He declared a state of emergency on December 17th, most recently, for a snowstorm. So it's kind of up to his discretion. Upon determining by clear and convincing evidence that the health of others is or may be endangered by a case, contact, or carrier, or suspected case, contact, or carrier of a contagious disease that, in the opinion of the governor, after consultation with the commissioner, may pose an imminent and significant threat to the public health, resulting in a severe morbidity or high mortality, the governor or his delegee, including but not limited to the commissioner of the heads of local health departments, may order the removal and or detention of such a person or a group of such persons by issuing a single order, identifying such persons either by name or by a reasonably specific description of the individuals or group being detained. Such person or group of persons shall be detained in a medical facility or other appropriate facility or premises designated by the governor or his or her delegee in complying with the subdivision 5 of this section. Okay, so there's a lot in this first big paragraph right here. One thing I would like to call to your attention is the fact that we have a lot of subjective language. There's a lot of things that could be determined in one way or another. And if you think, oh, well, it's pretty clear what they're trying to say, I would direct you to the Second Amendment, which has been a point of contention in Congress for now a very, very long time. People used to know pretty well what it meant, but in recent decades, there's been a lot of discussion. That language being necessary for the security of the free state, or a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So that language right there, the right of the people to keep and bear arms shall not be infringed, has now become open for interpretation. So if we can misinterpret something like shall not be infringed, how about something like suspected case or in the opinion of the governor? What might that mean? So this is a guy who is not a medical professional, and he has made some very poor health decisions for his people. Good example being sending infected patients infected with COVID back into nursing homes where that led to thousands of elderly people dying. That was his opinion. That was up to his discretion. So we're going to talk about the governor's discretion a lot throughout this. So I just want you to keep that in mind, what it is we're talking about. Also, keep in mind that we're talking about issuing orders for a single person or for individuals. So maybe a family. It's not unreasonable to believe that if there is one person infected, that the whole family would be considered contacts. And they would be rolling with you. Okay. A person or group removed or detained by the order of the governor or his or her delegate pursuant to the subdivision 2 of this section shall be detained for such period and in such a manner as the department may direct in accordance with this section. Notwithstanding any inconsistent provisions of this section, A confirmed case or carrier who is detained pursuant to subdivision 2 of this section shall not continue to be detained after the department determines that such person is no longer contagious. Now, we've been at this COVID thing for about a year. It is still up for debate how long someone is contagious. Keep that in mind. So how long you will be detained is based on information that no one purports to know yet. A suspected case or suspected carrier who is detained pursuant to subdivision 2 of this section shall not continue to be detained after the department determines, with the exercise of due diligence, that such person is not infected with or has not been exposed to such a disease, or if infected with or exposed to such a disease, no longer is or will become contagious. So no longer is and will become contagious. Well, how do we say that? There's no way to say that someone will or will not become contagious of a disease. That's impossible to say. So more subjective language there. A person who is detained pursuant to a subdivision 2 of this section as a contact of a confirmed case or a carrier shall not continue to be detained after the department determines that the person is not infected with the disease or that such contact no longer presents potential danger to the health of others. Now, again, let's talk about the fact that testing for COVID has been hit and miss. It's coming out more and more now that PCR testing is not particularly reliable based on the cycle threshold used in the United States, which is higher than most countries. The higher you go on a cycle threshold, the more likely you are to have a false positive. So this has been very well stated in medical literature for a long time and has been restated, but not very well conveyed to the public. Again, the United States uses a cycle threshold somewhere between 35 and 40 cycles, which increases the level of genetic material in a sample, which is what they're trying to find. So you can have a very small sample of genetic material, keep running it through cycles to enhance the material that we can see there, and then in that way pick out a virus per se. You know, there's a lot of things we can find in PCR testing. I mean, that's what we're looking for in this one. Another thing to keep in mind is it does have potential that RNA material from a virus that you've already been exposed to and are no longer contagious with because you have antibodies would show up in a PCR test. That means you could have had COVID, now be immune to it, and still, under these circumstances, be shown to test positive, which would keep you in a camp. All right. A person who is detained pursuant to the subdivision 2 of this section as a contact or suspected case shall not be continued to be detained after the department determines with the exercise of due diligence that the suspected case was not infected with such a disease or contagious at the time the contact was exposed. All right. When they're no longer a danger to others. A person who is detained pursuant to subdivision 2 of this section shall, or has appropriate with the circumstances, have his or her medical condition and needs assessed and addressed on a regular basis. Okay. Be detained in a manner that is consistent with recognized isolation and infection control principles in order to minimize the likelihood of transmission or infection to such person and to others. So this most likely would mean solitary confinement. If we're just saying isolation and infection control, right now in hospitals, people are very much isolated and they are not considered to be in prison, but they are not allowed to see anyone. So we would imagine in some sort of camp scenario, you would probably be isolated to whatever extent that would be possible. Okay, so when a person or group is ordered to be detained, and remember, person or group is ordered to be detained pursuant to subdivision 2 of this section for a period not exceeding 3 business days, such person or member of such group shall, upon request, be afforded an opportunity to be heard. If a person or group detained pursuant to subdivision 2 of this section needs to be detained beyond 3 business days, they shall be provided with an additional commissioner's order pursuant to subdivisions 2 and 8 of this section. Now, something that's interesting to me about this, again, that we're talking about a person or group. With anything else in this country, if you commit a crime, even if you commit a crime with a group, you are tried as individuals. Now, being sick is not a crime. However, this bill would essentially treat it as such, and you'll see later how that's really laid out. But we're talking about here when a person or group is ordered to be detained. So that doesn't happen in any other scenario except for this one. It's also very interesting to me that we talk about everything in terms of business days. So you will be detained without due process, but we're going to go ahead and stay on a business schedule. So if you would like to be heard over the weekend, you won't be. Section 7. When a person or group is ordered to be detained pursuant to subdivision 2 of this section for a period exceeding 3 business days, and such person or a member of such group requests release, the governor or his or her delegee shall make an application for a court order authorizing such detention within 3 business days after such request by the end of the first business day following such Saturday, Sunday, or legal holiday, which applications shall include a request for an expedited hearing. All right, so they will make an application for a court order upon your request. It doesn't mean they'll get a court order. After any such request for release, detention shall not continue for more than 5 business days in the absence of a court order authorizing detention. Notwithstanding the foregoing provisions, in no event shall any person be detained for more than 60 days without a court order authorizing such detention. All right, so it looks like we're putting a cap of 60 days, 2 months on your detention for maybe being sick. But that says 2 months, 60 days without a court order. All right, the governor or his or her delegee shall seek further court review of such detention within 90 days following the initial court order. The initial court order authorizing detention, and thereafter within the 90 days of each subsequent court review. In any court proceeding to enforce an order of the governor of his or her delegee for removal or detention of a person or group issued pursuant to the subdivision, or for review or the continued detention of a person or group, the governor or his or her delegee shall prove the particularized circumstances constituting the necessity for such detention by clear and convincing evidence. Wow, mouthful. Okay, so what we're talking about now is confining people up to 90 days with a court order, and then intervals of 90 days afterwards. And, just for circumstances they decide are necessary by clear and convincing evidence. I'm not really sure what that would mean. It would be appropriate for them to say here a positive test with these specifications or this specific evidence. Just like most crimes, you have laid out what it is, what's necessary to convict someone of it. Not so much here, more subjective language. 8. A copy of any detention order of the governor or his or her delegee issued pursuant to subdivision 2 of this section shall be given to each detained individual. However, if the order applies to a group of individuals and it is impractical to provide individual copies, it may be posted in a conspicuous place in the detention premises. Any detention order of the commissioner issued pursuant to subdivision 2 of this section shall set forth. Wow, okay. So if it's not convenient for them to tell you why you're being detained, they'll just post it up on the wall and you can read it if you can get to it. The purpose of the detention and legal authority under which the order is issued, including the particular sections of this article or other law or regulation. So again, this will be the thing they stuck on the wall. These sections will be what's on it telling you why you've been imprisoned without due diligence. A description of the circumstances and or behavior of the detained person. Let's read that again. A description of the circumstances and or behavior of the detained person or group constituting the basis for the issuance of the order. Now, I thought these orders were about public safety and isolating people who are sick, but now apparently your behavior will come into account. The less restrictive alternative that was attempted and were unsuccessful, and or the less restrictive alternatives that were considered and rejected, and the reasons such alternatives were rejected. Okay. A notice advising the person or group being detained that they have the right to request release from detention and including instructions on how such request shall be made. All right. Every prisoner has a right to request release. Doesn't mean they get it. A notice advising the person or group being detained that they have a right to be represented by legal counsel. Okay, this is interesting. And that upon request of such person or group, access to counsel will be facilitated to the extent feasible under the circumstances. All right, who typically needs legal representation after detainment? Criminals, or at least someone who has been charged with a crime. We are talking about people who are sick or suspected of being sick or were around someone that was sick. They'll give you legal counsel if it's available. Now, let's think about this in terms of how many people could potentially be in these camps. We're talking about thousands. We're talking about a big place. If this was to take place in somewhere like Manhattan, you have millions of people. And keep in mind, you think, oh, well, this may not affect me. I want you to remember that contacts of cases is grounds to be placed in one of these camps. And your phone and its recent updates, again, this is not a conspiracy. I would encourage you to look up how to turn this off. But your phone in certain updates uploaded contact tracing. You can turn it off, but Apple products all did this. They put a little thing in your phone where they will trace contacts of COVID cases. It's probably running on your phone right now if you haven't turned it off. So I'd encourage you to go look at that. But yeah, someone could essentially knock on your door and say, hey, you were in contact with someone who's tested positive for COVID. Come with us. All right. So let's keep that in mind. So it could be tons of people. You'll get legal representation when it's feasible. 6. A notice advising the person or group being detained that they may supply the addresses and or telephone numbers of friends and or relatives to receive notification of the person's detention, and the department shall, at the detained person's request and to the extent feasible, provide notice to a reasonable number of such people that the person is being detained. Now, the regular prisoner, a person charged with a crime and in prison, gets to make phone calls. Here, you're allowed to give phone numbers and addresses to whoever this will be, who will be in charge of these camps. And if it's feasible and reasonable, they'll let people know that you've been confined. In addition, an order issued pursuant to subdivision 2 and 7 of the section requiring the detention of a person or group for a period exceeding 3 business days shall advise the person or group being detained that the detention shall not continue for more than 5 business days after a request for release has been made in the absence of a court order authorizing such detention. So the good news is if they don't get a court order to keep you confined for longer, 8 days, only 8 days, only 8 days in a camp with no due process. Advise the person or group being detained that whether or not they request release from detention, the governor or his or her delegee must obtain a court order authorizing detention within 60 days following the commencement of detention, and thereafter must further seek court review of the detention within 90 days of such court order and within 90 days of subsequent court review. Advise the person or group being detained that they have the right to request that legal counsel be provided, that upon such request, counsel shall be provided if and to the extent possible. If it's you'll get legal representation if it's possible under the circumstances, and if counsel is so provided, that such counsel will be notified that the person or group has requested legal representation. Okay, if you kill somebody and have to go to court and you request counsel, you will be given counsel. If you just get sick, or maybe you know someone that got sick, you may get legal counsel if it's possible. A person who is detained in a medical facility or other appropriate facility or premises shall not conduct himself or herself in a disorderly manner and shall not leave or attempt to leave such facility or premises until he or she is discharged pursuant to this section. You better behave. Now, you've been in prison without due process, and you probably don't even really know why, but you better act right. keep in mind, they say this is a medical facility or other appropriate facility. Let's remember that at the beginning of the whole COVID thing, they had people on boats. They had makeshift camps in Central Park, sports arenas. So this could be anywhere, not necessarily a medical facility. And on top of that, keep in mind that if you do go into a medical facility and you decide to leave, you have the right to do so, at least before this was passed. You can do what's called, you can leave with an AMA. You'll have to sign a piece of paper. It means you've left against medical advice, and you're essentially taking the risk in your own hands, as you should always be able to. Not in this situation. You won't be allowed to leave. 10. Where necessary and feasible under the circumstances, language interpreters and persons skilled in communicating with vision and hearing impaired individuals shall be provided. Okay, why is this important? Where necessary and feasible. Where feasible. Now, I want you to think back where we just talked about the fact that if you request to be released because of this thing they stuck on the wall, if you go find that, and then you realize that you have the right to request to be released, then you'll go through that process of them getting a court order to keep you there. If you don't, they'll keep you for 60 days before they get a court order to keep you for longer. So if you are someone who does not speak English or any of the local languages, you won't be able to read that paper. And if there's not someone around to tell you what your rights are, you will be there probably no less than 60 days. And again, remember, there could be a lot of people there, and so it's very likely that someone with a vision impairment or hearing impairment could slip through the cracks and be very isolated and not understand what's really happening. 11. Provisions of this section shall not apply to the issuance of orders pursuant to 11.21 of the New York City Health Code. 12. Okay, in addition to removal of or detention orders referred to in subdivision 2 of this section, and without affecting or limiting any other authority that the commissioner may otherwise have, the governor or his or her delegee may, in his or her discretion, issue and seek enforcement of any other orders that he or she determines are necessary or appropriate to prevent dissemination or transmission of contagious diseases or other illnesses that may pose a threat to the public health, including but not limited to orders requiring any person or persons who are not in the custody of the department to be excluded, to remain isolated or quarantined at home or at a premises of such person's choice that is acceptable to the department. It's up to them. And under such condition and for such period as will prevent transmission of the contagious disease or other illnesses, to require the testing or medical examination of the persons who have been exposed to or infected by contagious disease or who have been exposed to or contaminated with dangerous amounts of radioactive materials or toxic chemicals. All right, so they can compel a medical test or examination. To require an individual who has been exposed or infected by a contagious disease to complete an appropriate prescribed course of treatment, preventative medication, or vaccination. All right, that's big right there. That means that they can force you to be medicated, even though they'll contradict that here in a minute. It says very clearly, require an individual who has been exposed to or infected by a contagious disease to complete an appropriate prescribed course of treatment, preventative medication, or vaccination, including directly observed therapy to treat the disease and to follow infection control provisions for the disease, or to require an individual who has been contaminated with dangerous amounts of radioactive materials or toxic chemicals, such that said individual may present a danger to others, to undergo decontamination procedures deemed necessary by the department. Such person or persons shall, upon request, be afforded an opportunity to be heard, but the provisions of the subdivisions 2 through 11 of this section shall not otherwise apply. The provisions of this section shall not be construed to permit or require the forcible administration of any medication without prior court order. So they say they can do it up here, but now they say they aren't without a court order. I don't know if maybe a court order that extends your time there would have this included. I don't know. But it does say pretty clearly that they can compel medication vaccinations right there. Section 12. Finally, this act shall take effect on the 30th day after it shall have become law. Effective immediately, the addition, amendment, and or repeal of any rule or regulation necessary for the implementation of this act on its effective date are authorized to be made and completed on or before such date. That's it. New York, A416 by Nick Perry. I tell you, that is scary. And it's not, if you've watched any of my videos before, you know I'm not on the fear mongering and all of that we see so much in the media. But that is a real document entered by a real member of assembly in a real state senate. I hope to God it doesn't pass. But even if it doesn't, that's where their head is at right now. We typically think in this country that the government is created to protect us, to protect our rights, protect our liberties. And laid out pretty clearly in that document, that does not seem to be their intended purpose there. So it's a lot to think about. And before you think, this is too crazy, this won't ever happen. If I told you a year ago that you'd be wearing a mask for the next 11 months, you probably wouldn't believe me. You probably wouldn't believe me if I told you in January of last year that in December, 25% of American adults would be food insecure. You probably wouldn't believe me if I told you 110,000 restaurants out of 660,000 at the beginning of 2020 would be closed by the end of it. So, we can't just know that this stuff is out there and think that's never going to happen, because we've done that. We tried that. Oh, it's never going to happen. You remember 15 days to flatten the curve? It won't be long before we're at the year anniversary for that. So keep an eye on this stuff. That's all we can do. We have to be aware of it and speak up. We can't just keep going this way, because it is my belief, and I think that belief has been reinforced this past year, that the government will take as much control as we let them, and they don't ever give it back. We've learned 6 months ago that COVID doesn't really spread on surfaces. Well, all the regulations that were in place to stop spread of surfaces, they didn't back that stuff down. So anytime we get new information, the WHO said months ago that lockdowns are way more dangerous than they are helpful. That hasn't stopped all the lockdowns. And again, before you say that this can't happen, it's already happening in New Zealand. And New Zealand was considered one of the freest countries in the world, ranked way higher than the United States. So this is for real. Go look it up and know that this is a possibility. And with the amount of hysteria out there right now and how afraid people are of this, again, a disease that's more than 99% survivable. And we're talking about concentration camps. And I wanted to say, I'm not saying concentration camp to try to be sensational. A concentration camp, by definition, is a camp where persons are confined, usually without hearings and typically under harsh conditions, often as a result of their membership in a group the government has identified as suspect. That's what this is. There wouldn't be a hearing before you were confined. And this is the government identifying a group, contacts, carriers, contagious. That's the group. And so we're very genuinely talking about implementation of concentration camps in the United States for a disease that is 99+% survivable. And again, before you think they wouldn't do that here, I'd ask you to direct your attention to the internment of Japanese citizens in World War II. 120,000 people were put in internment camps in this country for just being of the descent of the people we were fighting. And 80,000 of those people were second generation. They were Americans. And 46 years after the fact, the government came back and gave the people that were still alive $20,000. Most of those people they lost their homes. They lost their businesses. And 46 years afterwards, the people that were still alive that were in those camps, they gave them some money. So don't think that this can't be done. Don't think it won't happen. It may not happen, but don't think it can't. It absolutely can. So go read it for yourself. I would keep an eye on this. You can go to newyorksenate.gov and you can see as this thing moves through proceedings. You can see when it goes to committee, when it goes to the floor, when it will go for a vote. Hopefully, these people have enough sense to strike this thing down right away. Because like I talked about, with that subjective language in there, they could get away with anything, putting anyone in there, because you only have to be a suspected carrier or suspected contact. Oh, that's way too broad. Way too broad. And they're talking about taking whole groups into these camps. This can't be allowed to happen. If you're in New York, I really don't ever know if calling your representative helps, but hey, try it. Or just start talking about this. And that's what I would encourage all of you to do. I don't typically ask any people that watch my videos to do this, but I will say on this one, please, please share this. Share this. If you know somebody in New York, even if they're not in New York, share this with the people around you, because people need to be aware. They don't need to be worried about, is there going to be some insurrection act or martial law? Is there some shadowy figure that's going to come change the election? This is for real. This is not speculation. So share this. Let people know that this stuff is going on so they can be aware, because this stuff, it just gets quietly pushed into assembly. These bills quietly get passed when there's a lot of other distraction. And God knows we've got just about as much distraction right now as we ever have in this country. So share this stuff. Be aware of the reality that's going on out there. I appreciate you staying with me on this. I know it's not super exciting to hear somebody read legislation, but I do think it's important. And again, if you want to go review it, I think it's newyorksenate.gov. You can go, let me be sure on that. nysenate.gov. Yeah. So you can go check for yourself if you want to get more educated on this and be able to talk to people about it, because I really do think we need to be talking about it. So, let me know what you think. And again, please share wherever you can. I know the ability to talk about this stuff is getting harder and harder. So I don't know if something like this will stay on Facebook. But hey, hopefully. So thank you for watching, and till next time.